All right, I think I've got the signal ready to go. Good morning, Council. Welcome to the January 11th, 2022 docket of the Kansas Court of Appeals. My name is Amy Klein, and I'll be presiding over the matters today. With me, I have two very distinguished judges, Judge Henry Green, who's the longest serving member of our court, and Judge Patrick McEnany, who was a full-time judge in our court for many years and now helps us out as a senior judge. With that, I'm going to call the second case on our docket today, which is case number 123-641, the Fraternal Order of Police number 7 versus the City of Hutchinson. May I have the appearances of counsel, please?
Good morning, Your Honors. May it please the court, Mark Galis on behalf of the appellant Fraternal Order of Police number 7, Inc.
Thank you.
Your Honors, Miriam Bailey of the Polsinelli Law Firm on behalf of Applee, the City of Hutchinson, Kansas.
Thank you. Mr. Galis, since you're going to go first, you want to tell me if you want to reserve any time for rebuttal today?
3 minutes, Your Honor.
Okay, I've got that down. And before you begin your argument, because we are on YouTube, if you could give a little overview of the case, just so someone who's not involved will have some idea of what we're discussing. You know, keep it under a minute. I'm not going to count it into your time, but I do think it would help us out. So if you don't mind adding that in, we'd appreciate it. And with that, you may proceed.
Very well, thank you, and may it please the court. This is a judicial review action pursuant to KSA 60-2101D. Officer Jonathan Suda was employed by the Hutchinson Police Department as a police officer. His employment was terminated in November 2018 in connection with the handling of a traffic stop of a fellow officer. Pursuant to PERA, which is the Public Employer Employee Relations Act, the union and the city are parties to a memorandum of agreement, also called a collective bargaining agreement or labor contract. The contract requires just cause for any disciplinary action and contains a grievance procedure that provides for advisory or non-binding arbitration. The union grieved Officer Suda's termination, which went to non-binding arbitration before arbitrator Jeffrey Jacobs in April 2019. The arbitrator issued a written decision containing his findings of fact and an advisory award. The arbitrator agreed with the department that Officer Suda had violated department policy by turning off his body camera and failing to conduct impairment testing, but the arbitrator also found, based on clear and convincing evidence, that Officer Suda did not provide untruthful or deceptive responses during the investigation. Accordingly, the arbitrator found the department lacked just cause to terminate Officer Suda's employment and recommended reinstatement, albeit without back pay or benefits. Per the contract in September 2019, the city manager reviewed the arbitrator's decision, accepted the arbitrator's findings with respect to the body camera and impairment testing issues, rejected the findings on the truthfulness issue, and rejected the proposed remedy, thus upholding the termination. In October 2019, the city council affirmed the city manager's decision, and neither the city manager nor the city council heard live testimony or evaluated any additional evidence or found any additional facts. The union filed a petition for judicial review in the Reno County District Court in December 2019, and after briefing an oral argument in December 2020, the district court entered an order denying the union's petition, and this appeal followed.
Thank you.
Your Honors, the issue before the court, really an issue of first impression, is the role of the arbitrator in an advisory arbitration under PERA. The union's position is that while the decision or disposition of an arbitrator may be advisory in certain cases, the arbitrator is the finder of fact. And we base that view on the statute, the contract between the parties, as well as the city's conduct. First, with respect to the statute, KSA 75-4322Q provides a definition of arbitration, and it means, quote, the interpretation of the terms of an existing or a new memorandum of agreement or investigation of disputes by an impartial third party whose decision may or may not be final and binding. Arbitration is advisory when the results are not binding upon the parties. It is final and binding when both parties of their own volition agree to submit a dispute to and to abide by the decision of the impartial third party, end quote. In our view, the outcome or the decision is what is advisory, not the finding of facts. If fact finding were advisory as well, it would render arbitration meaningless. And while binding arbitration is always better, under the National Labor Relations Act and private sector arbitration, those arbitrations are binding. Non-binding arbitration is better than no arbitration at all. But even if this were ambiguous, the party's contract sets forth the role of the arbitrator. And that's the second point, is the plain language of the contract between the parties. This was negotiated between the union and the city in Article 6 of the labor contract, which is found at the first volume of the record, 27 to 28. It says that except when an agreed statement of facts is submitted by the parties, it shall be the duty of the arbitrator to hear and consider evidence submitted by the parties and to thereafter make written findings of fact and a disposition of the grievance, which shall be advisory in nature. Again, in our view, the disposition, meaning the proposed remedy, is what is advisory in nature and not the actual finding of facts. Further support for that, and this is important, is the conduct of the city throughout this process. The next step of the grievance process is that the city manager gets to review the arbitrator's decision. The city manager did review it. There were no findings of new facts. There were no hearings held, no additional evidence. It was simply reviewed. The materials were reviewed, and the city manager upheld two findings of fact by the arbitrator, but rejected the other, and then found that the Officer Suda should be terminated. Same with the city council. The city council then reviews the city manager's decision. Same process. City council did not take new facts. They did not have evidentiary hearing. There was simply a argument by council as to what to do. And so we think that is further evidence that the arbitrator is a finder of fact. Finally, in the briefing before the district court, the city completely dropped this argument. The union raised the argument of the arbitrator being the finder of fact. In the city's response brief, they not only ignored it, but when they set out the relevant provisions of the contract, they washed this fact finding out of it. Volume 2 at page 181. Their recitation of the contract provision says, it shall be the duty of the arbitrator, ... to make ... a disposition of the grievance which shall be advisory in nature. That's not what the contract says with respect to findings of fact. It's in there as well. And so we think all those issues together support the position that the arbitrator is indeed the finder of fact. And therefore, it was improper for the city to reject a finding of fact, but then still terminate him based on their view that he had lied, because that was the finding of fact at issue.
Well, counsel, I'm looking at the city manager letter here, and it seems to me that the arbitrator found that your client did not lie, and the city manager found, well, maybe he didn't lie, but he was untruthful and intentionally evasive. Aren't those two different things?
I don't think so, Your Honor, because I think the city manager was specifically rejecting the arbitrator's finding. I mean, the finding was that he had not provided untruthful or evasive or deceptive testimony, but the city manager completely disagreed with that and said, I find that this grievance was untruthful, intentionally evasive, contradictory, and deceptive. So I think that was a directly contradictory to what the arbitrator found. And again, remember that because there's just cause at issue here under this contract, the arbitrator's burden, the proof that the arbitrator required here was clear and convincing evidence. And in the arbitrator's view, there was not clear and convincing evidence, which is a common arbitral standard for a termination case. There was not clear and convincing evidence that Officer Suda had been untruthful. And that was totally rejected for no reason other than the city manager and the city had a different narrative of what had happened in this case. Does that answer your question, Your Honor?
Not really, because it looks to me like the language that both of the parties use is different, that the arbitrator found that your client didn't lie. And I mean, talk to me about why that isn't a different conclusion based on the facts than what the city manager found, which was, well, we still think that he was intentionally evasive in answering the questions. I mean, those seem to be, to me at least, to be two different things.
Well, I think the arbitrator did discuss it in terms of deception, in terms of evasiveness. I think that was at the core of the arbitrator's finding as well. I don't think it was simply a question of lie or not, and then, well, maybe it wasn't lying, but it was just deceptive. I think the arbitrator viewed it in the same kind of language that the city manager characterized here. At least that's my understanding of the award. So I think we are talking about the same things in terms of truthfulness. But again, I mean, the city manager's view, he took the view contrary to the arbitrator, despite not doing anything more than just having a different view of what had been presented to the arbitrator.
Thank you. The other question I had is, it seems to me that the determination by the arbitrator that your client didn't lie is a conclusion based on the facts. And that distinction seems important to me. Can you talk to me about that?
What exactly do you mean by that, Your Honor?
Well, I mean, maybe it's not an actual finding of fact. It's a conclusion based on the facts, that based on all of the evidence and the facts that were presented, he concluded that your client didn't lie. And that's his decision, which is an advisory decision. And the city manager, who has the ultimate decision along with the council, looked at the same facts and said, I conclude that he was still intentionally evasive, which is enough to support a decision of termination.
I think the important conclusion here, Your Honor, is the conclusion that the arbitrator's view was that there was not just cause to justify termination. The finding of fact was that he was not untruthful. And the disposition or decision from that was there's not just cause to terminate. The city manager's view was, well, I think he lied. I think he was untruthful. And then also in terms of the disposition saying, you're fired for the first two reasons and that reason too. So I think that's the ultimate disposition in the case from the arbitrator's perspective, I think, is that it was no justification for termination because it wasn't just cause. Now, I will say that, this doesn't, one possible, argument here from the city's side is, well, that ties the city manager's hands, the city's hands, whatever. There is a split in authority among arbitrators as to what constitutes just cause. There are some arbitrators who would say, well, 2 out of 3 ain't bad, and they could have fired him anyway for those first 2. There's also arbitral authority which says some lesser penalty could have been imposed because only 2 out of the 3 were found by the arbitrator. So it's not an issue of the city. It's not like this takes it out of the hands of the city. I mean, they still have a role in ultimately deciding, a recommendation from the arbitrator.
Along those lines, the finding of the arbitrator was there was ample cause for disciplinary action in this case. Is that true?
Yes. I mean,
am I reading that right? Okay. So there's, and action was called for, and under the contract with the union contract, the arbitrators to decide only questions of fact, and quoting, the arbitrator's disposition of the grievance shall be advisory in nature. Isn't the decision to overturn the termination and find that there's ample cause for disciplinary action, but it's not enough? Isn't that the arbitrator's disposition of the grievance? And isn't that what is essentially advisory in nature?
I think the disposition of the grievance in this case, the recommendation was reinstatement, but without back pay and benefits, because there was sufficient grounds on the body camera and the impairment testing, because the findings were that he had violated those policies. There was sufficient grounds to impose some sort of discipline. But the arbitrator's view is that it had to be short of termination because there was not clear and convincing evidence of untruthfulness. And so the disposition was to reinstate him without back pay or benefits. And I think that's a disposition that the city manager had to decide whether or not to impose. And the choice was to terminate, but it was not based on, well, the first 2 are sufficiently bad enough to warrant termination. It was, yeah, those are bad. Plus, we think he lied. Therefore, he's terminated. That's the distinction that we're trying to make, is that, there are arbitrators who would argue that two of the three are sufficient to warrant termination if they're severe enough. That'd be a whole different argument. I mean, I'm sure the union would have challenged it, but that's a different argument in terms of just cause and what constitutes just cause. But the problem we have is the fact that instead of just sticking to the two findings or adopting all the findings, two of the findings were okay, but one wasn't because it didn't fit a certain narrative. That's our problem here.
I take it you would, I trust you would agree that we should take note of the arbitrator's own findings or his observations in his opinion, that arbitrators should be cautious in mitigating penalties where there's been a clear showing of a violation of an applicable rule or policy, and that leniency is the province of the employer, not the arbitrator, and that that there was really no finding here by the arbitrator that the city was arbitrary and capricious, was there?
Well, I don't think the arbitrator was looking at it in those terms. I mean, he got the information, did the finding of facts to render a decision. Arbitrary and capricious doesn't come into what the arbitrator, he wasn't deciding. In his opinion, he talked about the only circumstances under which a penalty imposed by management can be rightfully set aside by the arbitrator. And then he talks about discrimination, unfairness, or capricious and arbitrary actions are proved, which to me is, which he equates to where there's been an abuse of discretion. He never finds that there's been an abuse of discretion by the city, does he? I don't think so. And that's a fair point. I just wanted to make sure that arbitrary and capricious, we were using that in a different way than in 60-2101, where there's that's one of the standards here. But, in terms of the arbitrator, his job in this case was to determine whether or not there was just cause supporting the termination. And he views just cause as the city had to prove by clear and convincing evidence all three violations. And because the city failed to do that, termination was improper, and something less than termination would have been appropriate because of the findings of the first two, the body camera and the impairment. And that's why he recommended no back pay or benefits, because that's, a significant outlay in terms of time away from the force. But so that's the just cause really is the main standard that the arbitrator has to go by in rendering his decision.
So the rest of the proceedings, going back to the city manager, then going to the city council, that's all just a rubber stamp, and it's rather superfluous in this contract?
Not at all. Not at all. The city manager and the city council have a number of remedies at their disposal. Like I said, the city manager could very well have terminated Officer Suda's employment based on the findings of the arbitrator with respect to the body camera and the impairment testing, because like I said, there are some arbitrators, there's a split in authority as to whether you have to prove all violations or just some portion of them. The city manager could have implemented some lesser penalty based on the findings of fact of the arbitrator. The hands aren't tied at all, because the opposite issue, Judge, is that if we were to take the city's view of this, then the city could do whatever it wanted, and it would render both the statute and the contract meaningless, because there could be findings of fact, there could be, days of hearings and evidence reviewed. And for the city just to simply say, well, no, we think he did wrong, we don't care what the arbitrator says, so it's all out and we're terminating him, that would render all of it a nullity.
Well, other than the fact that the arbitrator did find that there was ample cause for disciplinary action, and so you're saying that the city is their hands are tied with respect to that. They can't go beyond that. Is that what you're saying?
I think the city has to recognize the findings of fact and act accordingly. But that doesn't tie their hands. Like I said, they still could have had the same outcome in terms of termination if they'd wanted to, if they'd supported it in a different way. They could have imposed a lesser penalty. I mean, the arbitrator himself, saying no reinstatement or no back pay and no benefits with reinstatement. I mean, that is in the arbitration world, I mean, that's a significant penalty to reinstate someone back to work, but not pay them for all the time they were off. I mean, that's significant.
Thank you.
Counsel, if you want to keep some time for rebuttal, then we're going to have to move on. Do we have any other questions from the panel? Okay. And Ms. Bailey, since our questioning of Mr. Galis went a little more than his time, and I want to preserve time for rebuttal, we'll make sure and, expand your time to make sure we keep it even on both sides.
Thank you, Your Honor. May it please the court. I want to begin by addressing a few things that Mr. Galis mentioned and also some of the questions that the court addressed to him. Beginning with Judge Klein's questions about a distinction between the lying finding and the untruthfulness. I do think that's a meaningful distinction and one that is recognized in the Denning decision. Judge Green, I believe you were on that panel in that case, where the courts recognize a distinction between half-truths and truths, and half-truths are untruths if they infer a conclusion different from what would have been concluded had the whole truth been told. And that was an officer untruthfulness case, and one where the termination was ultimately affirmed. So I do think the distinction is meaningful. Going back to the contract, though, it sounds like we both agree that the contract is not ambiguous. We just have different views of what the contract actually says. The FOP's positions, both as to within the scope of its authority, substantial competent evidence, and arbitrary and capricious action, all of those are based on its view that the arbitrator's factual findings were binding on the city. And that's not what the MOU's clear terms say. Rather, the arbitrator's decision, its entire decision under the MOU's express terms, was merely advisory. The MOU provides in relevant part that it shall be the duty of the arbitrator to hear and consider evidence submitted by the parties and to thereafter make written findings of fact and a disposition of the grievance, which shall be advisory in nature. The arbitrator shall submit to the parties his or her decision in writing within 30 calendar days, ellipses. Upon receipt of an advisory decision by the arbitrator, the city manager shall within 7 calendar days render a written decision. The structure and usage of these provisions establish that the arbitrator's entire decision, both the disposition recommendation and the factual findings, are advisory. The provisions use two distinct terms, disposition and decision. And the thrust of the FOP's argument, that is that the word advisory modifies only disposition and not also findings of fact in the sentence within which both are referenced, ignores that the word decision encompasses both, and the word decision is later described as advisory. So that in the city's view, the FOP's contrary arguments are attempting to obtain, under the guise of construction, a term that the FOP never achieved at the bargaining table with the city. It's telling that even though the arbitrator at the hearing himself referred to the nature of this entire matter, as an advisory opinion, the FOP didn't object there or try to disabuse him of that notion in its post-hearing briefs. It's little wonder then that the arbitrator's opinion, labeled decision and award, in keeping with the MOU's decision term, also reiterates that the entire arbitration case, the entire case is, quote, advisory, not final and binding, by the terms of the CBA in place between these parties. That's at Record Volume 2, page 60. So based on this construction of the contract, The city council acted within the scope of its authority in treating the arbitrator's findings as advisory and making its own ultimate findings and affirming the termination. This construction does not render the arbitration procedure meaningless. It provides an evidentiary procedure that doesn't require the city manager, city council members to lend themselves to a role that they're perhaps not well suited to in receiving evidence, in making evidentiary rulings. It streamlines that reception of evidence process, gives the parties a full day in court with their attorneys present, allows them to make arguments, and then provides a roadmap, for lack of a better term, that the city manager could then consider in evaluating the evidence, him or herself, in evaluating the arbitrator's recommendation. I do think it's also important to touch on that the city did not waive or concede this position at the district court or otherwise. The facts and circumstances surrounding the city's non-waiver on this point are outlined in detail at pages 15 to 19 and 26 through 31 of the city's brief. I have no plan to repeat all of those here, but some particularly clear examples include that in the city's oral argument before the district court, the city's council explained that per the contracted issue here, the arbitrator's finding is not final, but is instead only an advisory opinion with written findings of fact to be considered by the city manager. And also said that the contract expressly requires the arbitrator to provide findings of fact, which are recommendations, and an advisory opinion, which is also a recommendation to the city manager to be reviewed. That's at record volume 3, transcript pages 20 to 21. Similar arguments were made at the city council hearing by the city's council, where the city's council was urged to weigh the credibility of the evidence before it. For example, in evaluating Mr. Suda's testimony that there were no signs of impairment at any time, with whether the city council believed there were signs of impairment. Because the sole basis argued in the FOP's briefs for its substantial evidence and arbitrary and capricious points is that the arbitrator's findings of fact were advisory, and because that position is incorrect as a matter of law, the FOP has established no basis for reversal. I'm glad to go into reasons, the evidentiary reasons that did support the city council's decision if the court would like, but that's also laid out in detail in our briefs, and I don't need to if you would prefer me not to. Does the court have any questions? Then in conclusion, the FOP and the city agreed to a grievance procedure for police disciplinary decisions. That procedure calls for 9 non-binding arbitration, and the MOU is clear. Mr. Suda had the benefit of that procedure as well as additional rounds of review thereafter. The substantial competent evidence developed through that procedure established that Mr. Suda did not act in the traffic stop and the ensuing investigation with the integrity that the city of Hutchinson and its citizens have the right to expect and require of their police officers. The city council so found and did not act arbitrarily or capriciously in affirming Mr. Suda's discharge. That decision, as affirmed by the district court, should be affirmed by this court. Thank you.
Thank you, counsel. Mr. Galis, you've got 3 minutes.
Thank you, Your Honor. A couple of points from the city's presentation. On the issue of lying versus untruthfulness, as I said, I think there's enough in the arbitration order which discusses the fact that the arbitrator found he not only didn't lie, but didn't mislead investigators as well. That is directly in the arbitrator's opinion. In terms of the meaningless nature, whether it streamlines the process or whether it puts the evaluation in better hands than the city manager, city council, it still, I think, would render this entire process meaningless. I can't speak for the legislature, but it would seem strange the legislature would put in effect something that was meaningless. It has to have some meaning. And our view in this case is that it has meaning to the extent that the arbitrator would be the fact finder. and that the disposition decision, the outcome, would in fact be what is advisory in nature. With respect to what the court can do with respect to this, the union would ask as a remedy, since our view, the union's view is that the decision making, because of the rejection of the finding of fact by the city, is that we would ask that this matter be remanded to the district court with instructions to reverse or vacate the city council's order to put Officer Suda back to work. At the very least, what we would ask for would be a new hearing with instructions about the role of the arbitrator as a fact finder, since, as I said, we believe that the statute, the contract, and the conduct of the city throughout has shown that the arbitrator is indeed the finder of fact.
Thank you. Any other questions from the panel?
Thank you.
All right. Thank you both for your excellent advocacy, both in your briefs and today. It really helps us in determining the case, and we will take the matter under advisement and issue a decision as soon as possible.